My name is Agrippino Kennedy. I use they, them pronouns, and this is Lex Personis, the official podcast of the New England Law Review. Today I'm speaking with Gracie Castle.
Yes, my name is Gracie. I'm a 3L here at New England Law, and I wrote this topic about AI and copyright and publicity rights, and I'm excited to get into it.
We're going to talk about AI, the gray area it occupies in copyright law, and what can be done about it. But first, let's hear a little about why Gracie chose this topic.
Well, I've always considered myself a creative person, so I'm very interested in creativity and also technology, and I wanted to write something that kind of encompassed what was going on in the day-to-day modern world, especially with such a digital world. And I think AI had been on my mind, and I definitely wanted to do something with AI. And then I was taking intellectual property, that class, and I was just like, okay, this is perfect. What can I do with this? And so I just kind of went through that.
Gracie noticed there was a lot of attention on this issue when it involved artists.
I saw a lot of stuff going on in the music industry with Drake and The Weeknd, that song. And I open up with my paper talking about that. And then also Taylor Swift and all that kind of stuff. So I thought that this could be a very interesting topic, not only to research for myself, but figure out if there are ways that artists would be protected against AI.
But she quickly realized famous people weren't the only ones suffering at the hands of misused AI.
Maybe not just famous people need protection from this either.
But before we get into all that, what is a copyrighted work?
Yeah, so first you need a copyrightable work. So that's going to be an original work of authorship, which means it needs to be independently created by a person. And it has to have a minimal degree of creativity. So it doesn't have to be something new or novel necessarily, but it needs to be somewhat creative. And then it also needs to be fixed in a tangible medium of expression. So it can't just be an idea floating around. It needs to be written on a piece of paper or uploaded to a website or something like that. It must be readable by another person or a machine. And then lastly, it just needs to fit into the proper copyright subject matter. So that would be a musical work, a literary work, pictorial graphic images, those kinds of things. Once you have that, you're eligible to be, you're entitled to protection.
Once a work is copyrighted, the author of the work gains what is called the bundle of rights.
Yeah, so once you get that protection, you have, like you said, a bundle of rights, which is you have the right to reproduce, adapt, publish, performance and display are also a part of those.
And this bundle of rights covers any works deriving from your copyrighted piece.
If I wanted to write an 8th book to the Harry Potter series, I wouldn't be able to do that because J.K. Rowling owns those copyrights. So that would be a derivative work adaptation kind of thing.
But authors can offer others the chance to use their copyrighted works.
And so you can lease those rights out to people. You can license them is what I mean. But yeah, so those are your bundle of rights.
Now there's this famous case in copyright law called MGM v. Grokster.
So in that case, it was about indirect infringement. And there are two ways that you can infringe on copyrights. There's direct and indirect. Indirect is basically if you're copying and assuming that copying is proven, it's gone so far as to appropriate or take over the original work. And that's pretty straightforward. Indirect, you can have contributory and vicarious. So if you know about it, and you're helping and contributing someone to infringe, or vicarious is you're profiting and you have the ability to prevent infringement and you don't do so.
Grokster had created a software for file sharing.
So in this case, Grokster was distributing free software that allowed users to share electronic files with each other, and that was mainly copyrighted material, so music. And they let their users download the music for free, made no effort to limit that infringement. So they weren't directly infringing, but indirectly infringing by letting people do that, basically using their software.
Now, Grokster had an argument for why this wasn't an issue based on a previous case brought against Sony, which stated that liability would not be imposed in situations where a product was capable of commercially significant non-infringing uses.
And when they went to court, they argued, well, our software has the ability to do non-infringing, like it has non-infringing use. And they cited Sony, this famous other case where Sony had created like a VCR and people were able to use that software to record like TV shows and watch them later. It was all about like time shifting, and the court there was not gonna give them, not gonna punish them, I guess, for it because it was an emerging technology and it could be used for non-infringing uses. And it was a software that, I mean, we use it every day now. And now we have like Netflix and like Hulu and all that kind of other streaming services, which is a totally separate subject. But Grokster cited that and was like, can we have the same excuse, please? Like, we're not really doing anything that bad here. And the court was basically like, no, you completely were promoting infringing. They were targeting users who had been using this other platform software called Rapster. I don't know if you remember that, like from way long ago, but they were targeting the users that weren't allowed to use Rapster anymore because it got shut down.
Gracie is referencing Napster here, an app developed in the 90s that allowed digital media sharing between users.
And marketing towards them, saying, hey, come use our services instead. They even would like help people do it. If people had questions about it, they would tell them how to do it. And so the court was basically like, you don't get this non-infringing excuse because you're promoting the infringement, and it's not something that you like. Your whole goal is to get people to infringe. Like, you're not using it for any other purpose.
So the court here was drawing a line between non-infringing uses in emerging technology and those which were meant for infringement. So what does that mean for AI?
And that was interesting and impactful because, one, it tells us that there is some limit to what the court thinks is like useful emerging technology. And I'm thinking like, well, AI could definitely be used for non-infringing uses as well. So like, where is the limit there, and that kind of thing. And then, yeah, it also, the court cares about new technology. So this really does go into an analysis about the ISPs and stuff in the DMCA and kind of how I talk about that framework later on in my paper.
ISPs are Internet Service Providers, and the DMCA is the Digital Millennium Copyright Act, which we'll get into later.
But yeah, it was a big deal. I think Sony was a bigger deal, but the fact that Grokster tried to say, hey, we have a non-infringing use, the court's like, that's not like a blanket excuse or defense in its entirety.
The issue with Grokster's defense was that they were trying to obfuscate from the fact that they had promoted infringing use of their platform, which the court found excluded them from the defense established in Sony.
It was being promoted and used for non-infringing purposes. Like, just because a software can be used for non-infringing purposes, if it's made to infringe, you're not going to be able to use that defense.
However, copyright protections are not absolute, and there are some ways in which someone can use a copyrighted work through what's called the fair use doctrine.
Yes, so the fair use doctrine is great. I think it's like the whole purpose of it is to promote creativity and freedom of expression.
There are 6 exclusions laid out under fair use.
There's 6 categorical exclusions from, infringement, and it's comment, criticism, news reporting, teaching, research, scholarship, and that kind of thing. So the fair use defense is, I would say, kind of broad, but only because you really need to prove that you've created this new thing that doesn't usurp the original work, but has brought like a new meaning and creativity to the subject matter or the material.
Another important piece of background information is understanding the right of publicity.
Yeah, it stems from the right of privacy, which I think is super important, especially because of the internet and everything can be recorded and whatever you post on the internet is there to stay. And that's not specifically tied to right of publicity, but privacy in general, I'm a big fan of. And so publicity is basically your right to control your own privacy. So it's protects against the unauthorized use of your name, image, and likeness. And so I like to think of it as like your brand. Like, I don't want my brand or my likeness being used in ways that I don't approve of, you know? And so I think when it comes to celebrities, that's really easy to pinpoint and say, like, okay, yeah, of course, like Beyonce doesn't want to be featured on a random advertisement that she doesn't endorse. Mm-hmm. But with individuals, they get a little tricky because, excuse me, a big factor behind right of publicity is that the person infringing is using it for a commercial gain.
Commercial gain is a big deal in publicity rights. In Fraley v. Facebook, a case from California in 2011, the court found that under a California statute protecting publicity rights, the economic injury of someone using your name and likeness for commercial use is a sufficient injury to bring a suit, even if you aren't famous.
And so, obviously, if Beyonce goes and promotes Cheez-Its without her consent, Cheez-Its is going to be making a lot of money off of that.
However, the doctrine of transformative use can undermine the right of publicity.
So transformative is like a fair use defense. And so it's basically, have you transformed this subject or material into something new that is its own creative work? And I always like to think of SNL when I think of this. So like you see SNL skits of people imitating or like doing parodies of celebrities. Like I think this past week they did skits about all these like TikTok influencers and we're like kind of making fun of them and doing that kind of thing. And so that's where that is kind of blended, where obviously the person being depicted has a right to their name, image, and likeness, but because it's a parody, it's kind of being transformed into this funny new creative thing, especially for SNL. I think they're probably, the best example of this because they do this every week. But so, and that's fair use. Like that's a very clear example of what fair use would look like done properly. So that's how that kind of works with right of publicity.
Now here I had to ask, what happens when copyright and publicity rights conflict? For example, a photographer taking a picture of a model. Who gets to claim the art produced from that?
So the photographer would have an interest and a right to the photograph itself. So like those bundle of rights we talked about, they would have those rights in regards to the photograph. The model doesn't have the same rights that the photographer has. And the photographer's bundle of rights is not dependent on whether the model consents to distributing those. So the model has an interest in how she or he is portrayed in the photo and how those photos are used, just because like how her likeness is used. So that's why models usually sign release forms, because then the photographer can use those pictures however they want. Well, within the limits, obviously, to whatever contract they write up. But yeah, so that's how those kind of work together.
So now that we get the basics, let's get into the DMCA, the Digital Millennium Copyright Act, and its impact on the field of copyright law.
Copyright changed, like our world has changed. So when the internet started coming around and is now here, very much here to stay, Congress was kind of like, okay, we have to set up some protections around not only copyright material, but also these internet service providers, which I'll call ISPs, from just constant litigation. And I think it also went into freedom of expression as well.
Congress was worried about a new surge in litigation around copyright without a sufficient framework for how to handle it. And Congress was also trying to balance free expression, a critical part of our democracy. And consistent with Sony and Grokster, the government doesn't want to limit emerging technologies when they have legitimate non-infringing purposes.
They are letting these platforms and encouraging these platforms to host user generated content without fear of constant litigation and fostering innovation online as well.
Which brings us to the impact of AI misuse generally, and the gray area it seems to occupy under current copyright laws.
Well, aside from just copyright in general, we see like a spread of misinformation with AI and like news reporting and that kind of thing. And then with copyright, I think that AI, you're able to scrape pictures off the internet or even voices and use them to either generate a new work or use them to exploit other people. So I talk a lot about like financial scams and revenge porn with AI. And yes, I think that I think the example that I use is AI users, like for example, Taylor Swift, there was a picture of her going around on Twitter or X, it's now called, and it was a sexually explicit photo, and it was being passed around, and people were seeing it and that kind of thing. And so I think that goes towards her right of publicity and how AI has kind of taken advantage of that. And whether it was used for a commercial gain or not, I'm not sure, but that's a clear indicator of how AI has manipulated people's publicity rights. I think for in copyright, I mean her music, I guess you could say, and her voice. People have taken her voice and kind of the tone of her music and the style of her music and made it into different songs. And I'm not sure that any of those have been published on Spotify. I know Drake and The Weeknd, that one was on YouTube and Spotify for a bit.
For those who didn't catch it, in spring of 2023, an AI-generated song created by scraping clips of artists Drake and The Weeknd was released to the public. The song was removed from TikTok and Spotify a few days later, and conversations began happening around whether it was actually a violation of Drake and The Weeknd's rights.
Eventually getting taken down because it's a clear copyright violation, but for things that are like pictures and phone calls trying to scam elderly people and using a voice of a relative or something like that wouldn't be under copyright. And that's why there is this like gray area and huge issue right now, because it doesn't, I think famous people or celebrities enjoy a lot of different advantages and disadvantages, to be fair, but things that we don't as ordinary people get because we don't have that same fame or recognition. And I see that more as like an issue with revenge porn and financial scams, because there is no real like immediate protection right now.
Now, a big issue resulting from generative AI misuse is what are called deepfakes, which the law has been slow to address.
Yeah, so deepfakes are just artificial images, videos, audio that are portraying someone or something in not a real way. But the scary thing is they look very real. And so, yeah, there's no like law necessarily protecting against deepfakes. I know that there's a couple of bills that try to address it, but again, some are state by state, some don't really encapsulate all of the issues that are going on with deepfakes. And so I think I talk about maybe having a federal right of privacy. That's like in a perfect world where that would be a situation where there would be more protection against it. But right now there's not like a comprehensive law that kind of fits everything into getting protection from deepfakes.
So what can be done? Gracie has some ideas, starting with removing the commercial gain requirement from laws and instead recognizing other types of harm done by generative AI misuse, trying to address the gray area.
Right. So yeah, like what I was saying before is that like you want, or you don't want, but an infringer would have to, or someone who's misappropriating your publicity rights would need in some states to have a monetary gain for that. And like when I was talking about the Cheez-It situation or example, like no one, I'm not, there could be a monetary gain, I guess, in some reality, but that's not probably going to work for me. For like financial scams, if someone is using, I talk about a Philadelphia attorney, and he went to Congress and spoke and was like, my son called me and told me he got into an accident. He's in big trouble and I have to go down to the police station. And yes, it sounds like the classic scammer situation, but it's different when it's actually your son's voice talking to you. And him being an attorney too, like he knew all of the details that go into like posting bail and the next steps, and so did the AI scammer. And so I mean, I think it just is becoming so much more sophisticated, but again, like, is that commercial use? That no. And it wouldn't even be protection for that attorney, it would be for the person's who his son whose voice was used. So that is an example of where that wouldn't fit. And then for revenge porn, I'm not sure that, I mean, I am sure that in some situations it would be used for commercial gain, but for the high school student from New Jersey who just had her reputation like crumble and her damaging, hurtful things were done because of what happened to her, and so she's not getting that that protection from this part of the law. I'm sure that there was some sort of solution for that, but for those things to be so widespread and happening so much more often than they were before, there has to be something new and something that encompasses everything and for everyone. But yeah, again, like, is there a commercial gain in that? I'm not sure. So
Gracie would recommend a federal statute designed specifically to protect people from AI misuse through privacy and publicity rights, but recognizes that may be difficult to swing. Instead, she recommends some amendments to the DMCA.
Yes. And for the record, I want to say, I don't know if it's a good thing that I'm saying this or a bad thing, but based on, because I literally wrote this paper about amending them, in a perfect world, we'd have a federal right of publicity. In a perfect world, we would have a federal statute or federal law about AI misuse in these situations. I don't necessarily think that amending the Copyright Act is the best way to go. But we're seeing that, like, it's been years with right of publicity issues. There's still not a federal law against it. And AI laws, I think that they do have the potential to be present and like actually happen. But in the meantime, my suggestion was to amend the DMCA and specifically those ISP frameworks. So right now, the DMCA doesn't protect against things that are not copyrightable because it's part of the Copyright Act. So one solution would be to include right of publicity in just that provision instead of changing all of the act. And then from that, you would have ISPs kind of taking a closer look at where user-generated content is available if AI was created, and just kind of monitoring that more closely, taking that into consideration. And then the second way, I think if we don't do that, then include publicity rights in the definition of a copyrightable subject matter. So like the audio, musical works, all that kind of thing, name, image, and likeness might be able to slip in there. I do think it could be tricky, but if there was a way where some more smarter people than me or knew more about it could figure out a way to have that be worked into it. And then also, I just think imposing liability on users who are generating AI content that is damaging, and having a clear words in the statute saying, like, machines cannot be authors, and AI machines in particular cannot be authors. And I think that the reason I said that is, yes, the Copyright Office usually is like, you have to be human. A lot of courts interpret that. Legislative intent behind that was supposed to be human, but how much human? Because if I'm inputting something in AI, I'm technically the one who's authoring it. I'm the creator of it. So wouldn't I be the author? So I think just having a very clear, like, it has to be fully human, like no percentage of AI or anything like that.
Gracie talks in her paper about the humanity requirement for authorship by pointing to a wildlife photographer's claim to a photo of a monkey. David Slater set up his wildlife camera and lured monkeys toward it, resulting in dozens of monkey selfies. Though he set up the camera, he was denied copyright protection because the monkey was actually the one who took the photograph. The U.S. Copyright Office then issued an opinion requiring that a work of authorship must be created by a human being.
And then also, one more thing about liability is, for right of publicity, if we do include that, then it wouldn't just be about commercial gain. It would be also, or damaging hurtful content to someone's reputation. And I think we can kind of pull from intentional infliction of emotional distress, like that kind of like avenue of how to construct a provision like that. But again, I think that the way that I kind of analyze this, I think it can be complex, and practically speaking, I don't know how well it would work. I think it would change the landscape of the Copyright Act and copyright law in general, because it wouldn't be just copyright anymore. So, but I think without a federal right of publicity and without federal laws limiting AI use, then this could be a solution.
A big part of Gracie's solutions to the gray area of AI surrounds the responsibility of ISPs to monitor generative AI misuse.
Yeah, so I think, again, like, this could be tricky because I have no intention of suggesting that we should limit freedom of expression and that kind of thing. But I think that in terms of ISPs, like, I know Google has like a take down and notice kind of thing. If you and I can just go on there and be like, my image is being used for something that I don't approve of, can you take it down? And so I think that ISPs that have not a reputation, but are consistently hosting AI generated content, that they should, take a little bit of a closer look, not only for copyright, because we have that pretty much covered with what they're doing right now, but just damaging content, explicit content. And again, like, we do have some measure of that, but sometimes if it's not involving someone who has a celebrity status or someone who's well known and just a random high school student, it's not I don't think that there's enough recognition there. And so that's kind of what I'm talking about in terms of liability.
Determining liability can be difficult when someone is using AI, because the person using AI isn't actually making anything themselves. They're asking AI to make it.
Like I said, I don't think machines should be authors, but when determining liability, the user who uses AI to create content that would infringe on other copyrighted material or misappropriate publicity rights, that would be the author. Again, I think using that same term could be confusing, so maybe it would just be like user or like creator.
Gracie differentiates here between the protections of authorship and the liability of infringement, arguing that an AI user who generates infringing content should be held liable as the creator of that work, but an AI user generating new content should not be granted copyright protections for that work since they aren't actually creating anything themselves. The computer is.
Right. I think it needs to be separate. So like, if I want to create an AI generated work using your image and I want to get it copyrighted, but I used AI, that's a non-starter. However, I think if you find out about this, even if it's not copyrighted, but it's out in the world, it's all over like Instagram or Facebook or whatever, I would still be liable as the author or creator of that work, and you would be able to get damages from
Gracie
me.
told me it's also important to factor in AI use when looking at a fair use defense.
Right. So again, like, freedom of expression is a priority, and so I think that when looking at transformative fair use, I just think that when we're analyzing whether something has transformed the original work, knowing that it was created by AI or knowing that AI was used, it should be taken into consideration. Like, it should be a factor in considering whether this person should be liable for this.
Gracie also wants to see better protection for everyone, not just celebrities.
Right. I think that, again, it should be kind of the same analysis of IED. I think you're right. Like, it would be harder to kind of figure out how much damage was done, but I just think that there should be some sort of base where people are confident that they can get protection from this, and there is some sort of law that will hold others accountable. And I just don't think that you should have a certain status in society to be able to protect yourself from having explicit photos be passed around to you around the internet, or or have like your voice used in a way that you didn't say anything. You didn't say that, but it sounds like you did. I just don't think that right now there's anything that's really protecting against those situations, unless you have a huge following that's like, oh my God, this really isn't right. Mm-hmm. Like, that was one of the reasons why those images on X of Taylor Swift got taken down so fast, because her millions of followers were like, whoa, this is not cool. Mm-hmm. And they reported the image and stuff like that. But for someone like you or me, I don't know, like, I'll get all my friends and family to do it, but how much does it take? What's the threshold for that? So that's kind of where I'm thinking that if you're creating content that's aimed to humiliate other people and damage reputation and hurt someone, then I don't care how creative it is. I don't care how much you've transformed it. Like, there should be a stop to that.
At the end of the day, AI is here and growing, and we need to find ways to regulate it.
I think that there is, like, the moral of the story is, like, don't use AI to hurt other people. And, like, fair use is still super important, but don't say that you're transforming something when you're really, what's the actual purpose? Like, mm-hmm. Going back to Rockstar, like, the purpose was infringement. Is the purpose to create something really cool and new, or is it to damage someone's reputation and hurt the other person?
But it is a complex issue, and even after all the research and writing, Gracie acknowledges that.
I have like a love-hate relationship with this paper, because I do really love the topic and I loved writing it, but it's frustrating too, because is amending the Copyright Act the right way to go? I don't know. Like, is authorship and liability, and how do those interplay with right of publicity? It's very complicated, but I'm happy that I was able to kind of get what was going on up here onto paper, and happy to talk about it today.
As new technologies emerge, it's important the legal system adapts with them to protect people from harmful misuse. Gracie gave us a great rundown of the gray area of AI in the law, and if this episode interested you, give her paper a read. It will be published in volume 59 of the New England Law Review. I read it with almost no background understanding of AI or copyright, and I found that I learned a lot about this very important, growing issue at the intersection of technology and law. From the New England Law Review, this has been Lex Personis. I'm your host and editor, Agrippino Kennedy, and I wanted to give a special thank you to Dantes Nava for our intro music. Thanks for listening, and we'll see you next time.